Dear students, today we can solve one problem under Transfer of Property Act, which has been given under the Karnataka State Law University previous question paper. Here, the problem runs like this. Here, A makes a gift of all his properties to his brother-in-law. However, he makes no mentioning of his debts. Is any remedy is available to the creditor? So that aspect we have to explain. Here, this aspect we have to explain. That means a person A, he in order to defraud his creditors, what he has done, he has transferred his property by way of gift to his brother-in-law. So, at that time, whether the creditor has got any remedy available under the eyes of law, definitely has got the what you call remedies. Here, the bona fide creditor, he has got the remedy. Here, what happens, who is a creditor? The term creditor means a person to whom a debt is due or a sum of money is due. That means here under Mohammedan law, a wife, if her dower is not paid, she is also a creditor. Under Hindu law, if the wife, her maintenance is not paid, at that time she will be called as creditor. So that aspect Here, what we have to see, we have to solve this problem under the provisions under Transfer of Property Act. That means here we have to follow the IRAC method. Here we have to frame the issue. Here whether the creditors of A have any legal remedy. That you can make the frame the issue. That is you have to frame the question out of the problem which has been given. When A gives away all his properties to his brother-in-law without mentioning or providing for his debts. That means here what happens if a person transfers his property with an intention of delaying or defeating the creditor, at that time what is the remedy available? So at that time we have to frame the issue according to the problem which has been given. So that is the issue. Then we have to go for the rule. That means here we are very much restricted with regard to this what you call format. Here what is the rule? Here under section 53 of the Transfer of Property Act, it has been provided that if any transfer of property has been made with the intention of defeating or delaying the creditor, at that time the such transfer is voidable at the option of the such creditors. So to whom the person is going to defraud the creditors, so they can go to the court, they can ask for the remedy, and such transfer can be voidable. So that is provided under section 53 of the Transfer of Property Act. Here we can see there is also, we can refer section 2 subclause 9 of the BNS Act, what is meant by fraud. So that has been given under IPC, under section 25 also it was being provided. So that aspect we have to explain. And the Supreme Court has also retreated this aspect with regard to which are all the elements of fraud, which are all the elements of the defrauding. That is, here the Supreme Court in the case of Dr. Vimala versus Delhi administration, it has this honorable court has said that there are two elements are there, that is deceit and the injury to the person deceived. So this aspect it has been said under this case law. That means overall what we have to say, any transfer has been made to defraud the creditors, such transfer will held to be avoidable at the option of the creditor. So this aspect has been said under the case law of Ram Narayan versus Pushkar Nath also. And here what has been said, a voluntary gift made by a debtor with the intention of defeating creditors can be challenged and set aside. Likewise in Krishna Kumar versus Pushpa Devi also, it has been said, the Supreme Court held that if a gift of property is made without providing for existing debts, creditors have the right to seek the remedies under Section 53. That means the transfer can be made with the suitable arrangements to repay the debt. But with regard to the not making the suitable arrangements and keeping what you call the such transfer under sham or under abeyance, that means not disclosing such transfer to the creditors. And if any suspicious transfer has been made without the knowledge of the creditors, at that time such transfer will be held to be voidable. So this aspect we can see in official assignee of Madras versus Sampath Naidu also. So these are all very simple thing, but you have to write according to this the format, then you will get the proper answer. That's why what you have to do, if you follow this IRAC method, you will get the correct answer. Here you have to write all these things. What is the issue has been discussed here, and what is the rule will say, and here you have to discuss all those things under the application part. Here what has been given, A has made a gift of all his property to his brother-in-law. However, he did not mention his debts, nor did he make arrangements to settle them. So this aspect we have taken from the fact. That means we have to the aspect of which has been given under the fact aspect, which has been simplified under the analysis. What we have to do, analysis or application, what we have to do, we have to simplify the facts, and we have to take the issue, and we have to take the rule of law, then we have to find the answer for that one. That means entire thing we have to discuss under this application or analysis. We can say this can be analysis part also. So this aspect we have to discuss this aspect under the analysis part also. So this is the thing what we have to, if we do this aspect, we can get the answer. So we can call this as application or analysis, and next one is conclusion. Naturally, conclusion is that remedy is available to the creditor, and they are very much protected under Section 53. The courts can grant the relief. So these are all the things we have to write with regard to the present problem. And here this problem has already been done in Kannada medium. Those the Kannada medium students, they can look into this problem in the what you call Kannada Nyayadhare. That is the same channel, playlist is there. You can look into that problem.